Hi, everybody. I'm Brian Klaus. I'm an instructor in the dispute resolution concentration in the Master's in Legal Studies here at the law school. I'd like to talk for the next few minutes about dispute resolution outside the courts. This is me. I'm from Chicago. I'm darn proud of it, and you would be if you lived here too. But our point today is how do we find resolution without litigation? I've been practicing for over 30 years, and I quit practicing as an advocate decades ago. And why is that? Here's why. You're all training to be advocates. And what do advocates do? Well, they argue. They try and get an answer. Plaintiff, defendant, accused, the state, claimant, respondent. It's a binary approach to a dispute. We've all heard the phrase, there's two sides to every story, and we all know that's baloney because there's dozens of sides to every story. Every person who views an occurrence or participates in an event, they have their own perspective, and it doesn't always divide into two competing sides. So arguing about it in this binary system, is that always a good way to solve things? Well, it'll get you an answer, but it won't get you a solution. So fundamentally, we need to understand what we need by dispute. We can use it to mean the verb dispute, to argue. We can use it as a noun to show that we have a disagreement. For us, we're going to talk about two or more differing positions. So we're all involved in dispute resolution because, well, we're alive and communicating with people around us. So think of some dispute resolutions. I mean, some disputes, actually. So we can think of this two kids arguing over a toy, the kids in the back of the minivan, people at work, things like that. We all have a hand in resolving those disputes, whether it be with our siblings, our partners, our children, in our family, our extended family, the cousins, aunts, and uncles. In the workplace, we've all had a dispute in the workplace with a coworker or a supervisor or somebody who we supervise. In the community, we can think of all different things from the minor, reaching for the same thing in the grocery store, to the major, road rage, and everything in between. These are all the everyday interactions that we have that need to be resolved. I'm not talking about a big formal process, but think about the ways you've been involved in disputes. Maybe you have a friend who needed some dating advice and they came to you. Well, you were helping to resolve that dispute by having conversation with one party or both parties. When we go back to this earlier one, maybe you're that parent, pulling out her hair who says, okay, here's what you're going to do. Well, you arbitrated it. So let's talk about a couple of those things. The three key ways you will learn to resolve a dispute are the fundamentals of the legal framework for how we resolve things. First is negotiation. Negotiation doesn't work. Sometimes you go to mediation. Mediation doesn't work. Sometimes you go to third-party resolution. Now, this is not a continuum. You could start out with mediation. You could just go right to third-party resolution. Before there's even a claim filed, you can begin negotiations. It depends on if there's an agreement between the parties, written or oral, a past history of how they resolve things, and various other factors. The first of those three is negotiation. And negotiation is pretty simple. Various parties talk. That's it. You talk about it. Maybe you send over an email or a letter or something that further explains your position. And that can be the basis for the conversation. In the legal framework, it often is the beginning of the conversation. In advocacy, you may see something called a demand letter, or you may be asked to come up with a demand letter. And what is a demand letter? It is what you're demanding. No secrets there. Uh, it's what you want. The person you represent has been wronged or injured, or a contract has been broken, and you believe that they're entitled to money damages, and you're going to explain why. So that invites the conversation from the other side. Learn how to do this. This is how more than 90% of things are resolved in legal disputes, is through negotiation. It's not by going to court. Mediation. That's pretty simple too. That is a conversation in which a third party guides that conversation. You may have heard in the news that, we're going to get a federal mediator for a labor dispute in a workplace. Well, that's the Federal Mediation and Conciliation Service. And they have trained mediators, hundreds of them throughout the country, and they come out and resolve disputes. And there's all sorts of mediation. You name a profession, an area of dispute, construction, employment, education. The list goes on. And there's mediators that are skilled in that area. It requires training to become a skilled mediator, and you'll hear about the various approaches as you study mediation. There's facilitative, which is just a lot of listening, transformational, where you try and get parties to a greater understanding and change the dynamic of the relationship, or evaluative, where the neutral mediator at some point gives their opinion on the merits of the dispute. And you'll hear as you're taught these various approaches, just like the earlier slide with negotiation, mediation, arbitration. They don't necessarily work on a continuum. They don't necessarily work separately. A good mediator is going to employ techniques that use facilitative, transformational, and evaluative based on the situation. But it is something also like negotiation that you are going to want to know, because at some point you'll be involved in a mediation, whether a formal mediation or an informal mediation. Arbitration. With negotiation, the parties talked amongst themselves. With mediation, a third party came in and guided the conversation by asking questions, giving suggestions, things like that. In arbitration, it's essentially a private judge. Somebody else comes in and they decide what should happen with your dispute. So as opposed to negotiation and mediation, where the parties can come up with a solution that's tailored to their needs, that everybody is equally happy with and unhappy with. Well, maybe not equally, but they can live with it. Arbitration brings in a judge, and there is then no room left to negotiate or to mediate or to craft a resolution that gives us a solution as opposed to the answer that I mentioned earlier. So this gives you an answer. One side might not like it. The other side might not like it. Everybody may hate it, but you're going to get an answer. So it begs the question of, what do we need to learn to understand negotiation, mediation, and arbitration as we venture out to be advocates? I think you need to know some about all of them, more than just this 15-minute video. So there's some courses. And these are all in the dispute resolution concentration. It's Introduction to Dispute Resolution, a deeper dive into the three topics that I just mentioned. Workplace Alternative Dispute Resolution. I teach that. It's a lot of fun. And it takes a case all through the arbitration process. The interesting thing about a workplace dispute under collective bargaining agreement is you don't have to be an attorney to be an advocate. So we use a case like that and run it through the process. International alternative dispute resolution. There's huge commercial, well, and more than commercial. You can have various treaty disputes, a host of disputes that exist through companies and organizations and agencies in different countries. And every country is going to have a slightly different perspective on how arbitration is done in their country. There's some overall parameters you would learn that are good for all of it. A very good course taught by Katie Simpson and Edna Aguirre. Very good. A lot to be learned there. Interviewing and Counseling, a course developed by Professor Barbara Bergman, one of the leading criminal law professors in the country. This is currently taught by John Weathers and Jennifer Sullivan, a former Federal Mediation and Conciliation Service mediator and a former Chicago prosecutor. They know how to interview people. They know how to advise people. Mediation, terrific course. If you take this course, you will get a certificate that that states that you are qualified. You've done a 40-hour course and qualified to mediate. I think in just about every state. You can't do family law mediation in most states because that's separate, but you could do disputes, landlord-tenant, commercial, business. It's good training to have. That is taught by Chrissy Taylor and Deandra Roche, who are outstanding mediators. A lot to be learned in that course as well. Advanced negotiation. Jeannie Charles and Aisha Jones. They will take you beyond the mere basics of negotiation and teach you what you need to know about how to negotiate effectively for the advantage of your client. Another outstanding course, a lot to be learned there. At Family Law Mediation, team approach to this, great people on that team. If you're interested in family law, you need to understand family law mediation, because if there's kids involved, chances are the court system is going to send you to mandatory mediation over those children. And in addition, family law is going to have a third party. I mentioned earlier the binary approach to getting a solution. Family law is going to add that third party. They're going to add the GAL, the guardian ad litem. That is an attorney that represents the best interests of the child in the family law proceedings. So that's an overview of what's offered in the concentration and in the Master Legal Studies. You can certainly contact the program to get further information. There's excellent instructors. It's all online, and they're all very involved. Good luck in your future.